Welcome. Thanks for being patient and staying with us. I'm Lewis Izzo. With me is Julian Arndt, Associate Director, Australian Business Lawyers and Advisors.
Hello, everyone.
Yes, so apologies first up. We had a little bit of a technical issue involving the internet, which delayed our commencement, but we're up and running now. So thanks for bearing with us. We have an action-packed schedule today to talk about leave. We'll still promise to get you out of here at 1 o'clock, so we will let you get back to your busy working days. Leave's not a small topic to attack, Julian, because there's obviously various facets to it. We've put up on the slide there that you'll see a range of different areas that we're going to look at exploring today, starting with effectively a groundbreaking decision in the federal court pertaining to Mondelez. They had some significant issues or a dispute around personal carers leave accruals and payments for taking leave. We're going to explore that. And we're then going to tackle each of the topics that you'll see up on your slide, from annual leave all the way through to unpaid community services leave, and talk about the correct way of handling these types of leave. We're going to talk about some common areas where employers fall down so that you can kind of be aware of the little landmines that exist and the typical processes you need to be adopting when managing leave in your business. So that's effectively what we're endeavouring to tackle. I should say that for those that were expecting Sophie Wish, apologies if you're disappointed. This isn't Sophie. Sophie was unable to come at the last minute due to an urgent work commitment.
Lewis, I'm going to try my best. Leave is a very interesting issue. By definition, leave, it's not work, but clearly it has a massive effect on the workflow, on employers, and so much is proven by the fact this is an incredibly well subscribed webcast. So it's one of the most popular webcasts we've ever had, which shows that leave, notwithstanding that people aren't doing any work on leave, it's certainly something that's affecting all of our viewers.
Agreed. Well, with that, we might jump into it, Jules. So Mondelez, this decision has really stirred a bit of the hornet's nest, for want of a better phrase, in relation to personal carers leave accruals and the way the personal carers leave is taken. So to paint a broad picture, there was a dispute between Mondelez, which is effectively the owner of the Cadbury brand of chocolates, and the Australian Manufacturing Workers Union.
They describe themselves as a snack foods powerhouse.
They are a snack foods powerhouse. And in that decision, there was a dispute about the payment for personal leave. Now, as many of you be aware, the Fair Work Act entitles employees to 10 days personal leave per year, personal carers leave per year, and it is generally accrued by reference to one's ordinary hours of work. Mondelez argued that 10 days is really 10 notional 7.6-hour days. So that is, they said, well, when we talk about what a day is, it's this reference to your typical day for a 9-to-5 worker working Monday to Friday.
38 hours a week.
Working 38 hours a week. You get 10 of them, which effectively equates to 76 hours in a year, or 10 lots of 7.6 hours. The AMWU argued, no, that's not right at all. A day is a day is a day. You are entitled to 10 days off a year, 10 24-hour periods, and you're entitled to payment for your ordinary hours of work in that period. And the federal court, after weighing up the varying arguments, sided with the AMWU, and it said, that's right, what the meaning of a day is not contentious or controversial. It's a 24-hour period. It commences when you were rostered to commence work on a particular day. And so what that means is all employees have an entitlement to 10 calendar days leave a year. Now, that poses two particular problems. The first is, for 12-hour shift workers, it means if you're working 12-hour shifts or 10-hour or 11-hour shifts, you actually end up getting 10 lots of 12 hours off a year. So if you work 4 days on, 4 days off, and you're working your 12-hour shift, then you're actually getting 120 hours of leave a year instead of, say, 76, like most other workers would. That's a bit of a groundbreaker for many employers because most employers don't accrue that way. Most leave accrual systems and most payroll systems accrue a maximum of 76 hours of leave in a yearly period. So that was one particular headache that was concerning Mondelez, and it really meant that their accrual needed to change because what they had in their systems was deficient for their 12-hour shift workers. And the same, as I said, would apply to anyone working 11-hour shifts or 10-hour shifts or 9-hour shifts.
This can get very complicated, and we'll try not to get too complicated. But the other scenario, Lewis, would be if you worked a pattern of work which didn't necessarily mean you worked the same amount of hours every day. So maybe on some days you're working 12 hours a day, but on other days you might be working, say, 4 or 6 or 8. You would actually be entitled to differing amounts of payment should you take leave on those particular days. So it does get very complicated.
It does, and this feeds into the second problem that has caused particular concern for employers, and that relates to part-time employees. Because the Act says everyone gets 10 days leave a year, that also means that part-time employees are entitled to 10 days leave a year. Now, universally, in our experience, employers are not accruing 10 calendar days of leave for part-timers a year. What employers accrue is a pro rata amount. That is, if an employee works a 50% load, they work 2.5 days a week, they work half the load of a full-timer, they usually accrue half the amount of personal leave. And what the federal court has said is that's not the correct way to apply the Fair Work Act provisions. You're entitled to 10 days. And so again, employers are finding that their payroll systems are not aligned to the actual way in which you should be calculating your leave for part-time employees. And to get to Julian's point, if your hours vary and you work 5 hours one day, 10 the next, 3 the next, depending on the day, each of those is a day off, but what gets paid will differ. Now, no employers are really approaching things this way. Employers are simply deducting hours. They usually accrue in hours, and what the federal court's really saying is, well, that's great, but that's not what the Act talks about. It talks about accrual in terms of days, and you need to ensure, no matter how long the shift, no matter whether they're part-time or full-time, that they all have access to 10 calendar days a year, which accumulates year to year.
It's interesting. Generally, when we find big cases come out from the courts, they kind of determine at one side of a grey area. It's fascinating that in this case, we really do have the court's decision going against almost universal practice of pretty much all employers that at least we're aware of. The other aspect, which Lewis may touch on, is part of the reason why this presents difficulties is because payroll systems that employers currently have in place either are not, and at least for some scenarios, there's a question whether they cannot deal with the fact that the accrual needs to be in terms of days as opposed to hours, and what a day is actually worth may vary based on the employee and what day they actually take.
So it's an absolute mess. We have a scenario where the decision in Mondelez has been appealed. It's been taken to the High Court. So the company and the Minister for Industrial Relations, who's also the Attorney General, Christian Porter, has intervened, he's also appealed, seeking to have the decision overturned. High Court appeals are not speedy processes. We could expect that it could take up to a year to have a full resolution. There's got to be an initial preliminary hearing as to whether the appeal goes ahead, then the full appeal hearing, and then you've got to wait the decision or the judgment. So we could be talking about 12 months at least until this issue is resolved. In the meantime, we have employers who, in all likelihood, are probably accruing personal leave in a manner inconsistent with the federal court decision. And I think that then presents a challenge for employers as to what they do about it. Now, obviously, as employment practitioners, our first and overarching advice is you should always comply with the laws of the land as they stand. So technically speaking, you would need to be ensuring that your payroll systems now reflect the latest decision. There are, given the level of effort required to perhaps review and audit your payroll process, to review and audit what employees are being paid, there may be other ways that some employers might go about things. They might try and assess it more on a case-by-case basis, isolated cases when an issue comes up or a concern arises. That's what we're seeing a number of employers do. But obviously, as an overarching advice, employers do generally need to ensure they're compliant with workplace laws. It's really an issue you need to grapple with. Just form a view as to what you're doing with your business. Is it compliant? Is there another way of accruing hours, particularly for part-timers, that you might need to look at? Particularly if someone's exhausted their allocation. If they haven't exhausted their leave allocation, it's not really an issue that might arise at the moment, but it's where people run out of leave, you might actually have a shortfall.
The other aspect is to the extent that there's any aspect of being able to cash out personal carers leave, as well as the shortfall. So we're not going to deal with claims or disputes in every case, because obviously people on termination generally don't get paid their personal carers leave out. So we don't need to deal with this or any shortfall or any accrual entitlement at the end of people's employment. The other aspect, which is probably more fundamental, is it's very likely that your contracts and your policies are probably wrong in respect of the current state of the law.
The Fair Work Information Statement was, and they've rectified that to address the decision.
Yeah, absolutely, and the Fair Work Ombudsman has quietly changed their advice about personal carers leave following the decision, and sort of as the law changes, the advice changes. But everyone is dealing with this. It's not something which there's been one school who was right and one school that was wrong. Essentially, I think almost universally employers have been fallen on the wrong side of this one.
So we've got a couple of questions, Julian, that we might deal with briefly. Stephen asked, what happens in the Mondelez case when staff take a part day? That was looked at. The court said you can take a part day of leave, and then what that means is you deduct part of a day from their accrual. So if someone takes half a day of leave, you would deduct half a day, or 1/20th, effectively, of their yearly accrual, because they get 10 days of leave. So you would deduct a 20th of their annual accrual. So they didn't say that this approach precludes taking part days. They said you can take part days, but that then means you need to deduct the appropriate fraction of the employee's accrual, which would really be 1/20th of their yearly accrual in the case of someone getting 10 days a year. Peter asked, what about casual employees? This doesn't affect casual employees, provided they are truly casuals and they're genuinely casual employees. They're not entitled to paid personal or carers leave. And then we have Jody saying, should employers be back paying any personal leave if they haven't been accruing this way? This is really this issue that we discussed before, Jody, about, how do we go about dealing with the issue in the interim? We know there's a High Court appeal. We know the government might even intervene to amend the legislation if the appeal is unsuccessful. So if that's the case, what is it that an employer does today in November 2019 to address this issue? And it's not an easy one to advise on because, as I said, we're kind of bound to tell you to ensure you're fully compliant. But I have to say, most employers really are hoping that rather than forensically upturn all their books, recalculate all the sums and back pay people, that they just deal with any complaints that arise on an isolated basis until this mess is sorted out. That's the only other option commercially available, really.
It's a massive overhaul. So to the extent that it's not necessary yet, I think the prudent course would be not to do anything. Where it is necessary, as we discussed before, is where someone has run out of leave and under the current state of the law, let's say they're a part-timer, they work a 50% load and they've taken their 5 days personal carers leave, and all of a sudden under your system currently, they're at zero. Well, under Mondelez, they've got 5 to go, and to the extent that you don't pay them, you've got an issue.
Well, a breach of the Act. And so that's the issue everyone really does need to grapple with. So that's the Mondelez case. We will come back to personal leave in a bit more detail shortly, but we might move on to then leave more broadly. Annual leave, just some basic rules around accrual and taking leave. Some things that are up there won't be surprising to some people. Most full-timers get 4 weeks annual leave a year. If you're a shift worker, that is the award or the enterprise agreement that applies to an employee defines them as a shift worker, then they get 5 weeks. If you don't have an award or an EA that covers you, then the Act has its own definition of a shift worker, which is someone who regularly works, is a 7-day shift worker who regularly works Sundays and public holidays. That's the definition the Act adopts. So the basic accrual is 4 weeks full-time and 5 weeks shift worker. You have the same interesting question that arises about part-timers and leave accruals. Again, the language is similar to that considered in the personal leave scenario. So there is an argument that the Mondelez principles also have application to annual leave, and that really part-timers are also entitled to 4 weeks leave a year. But that's less of a concern, because really what we would say is, well, 4 weeks for a part-timer, if they took it in weekly blocks in particular, well, they're still going to get only payment by reference to their part-time hours. So it's not as problematic as the daily entitlement, which we dealt with in the personal leave scenario. Taking leave is perhaps where we get a little bit more tension. Leave is to be taken at times that are mutually agreed between employers and employees. And an employer can only refuse an application for leave by an employee if there are reasonable grounds to refuse. That is, you cannot unreasonably refuse the taking of annual leave. Now, what's reasonable will depend in the circumstances of every case. It might depend on the operational imperatives at the time, could be a busy period for the business, might depend on the employee's specific circumstances and whether there's an absolute necessity to go off. It might depend on the notice that's been given, on cover that can be arranged, on financial cost associated with the leave. So all those things will be factored in. But the short position is it's generally taken by agreement, but just remember that employers cannot unreasonably refuse leave. Now, where we get into some more technical and problematic areas is when employers want to direct the taking of leave.
This is your favourite topic, isn't it, Lewis?
I don't know about my favourite topic. It's a bit of a bane on my existence sometimes. But not that I'm going around directing people every week, but there's two things to factor in. Firstly, for award-free employees, test is reasonably simple. You can direct the taking of leave provided the direction is reasonable in the circumstances. So we're back to that reasonableness test. What's the business need? How much notice have you given? What are the employee's circumstances? However, where an award or EA applies, different rules apply. You can only direct the taking of leave if it's in accordance with the provisions of your EA or if it's in accordance with the provisions of your award. Now, that gets really interesting because we have here, and I'm not sure if you can see on the screen, but I'm putting up for everyone to see. We have here the kind of sample leave provisions around excessive leave accruals, and they're anything but simple, really.
Well, it's a 5-page document.
The leave provision is extensive in many of the awards, the model clause, and when it comes to excessive leave accruals, whether you can direct the taking of leave actually has quite an extensive process. The provisions commence by setting a rule as to if someone's leave accrual is excessive or not. So under most awards, they need to have 8 weeks annual leave or 10 weeks annual leave accrued for shift workers before you can direct an employee to take annual leave. The rules then go on to talk about the fact that an employer must genuinely try and reach an agreement with the employee to take the leave before any direction is issued. If a direction is issued, then the direction must not result the employee in ultimately retaining any less than 6 weeks annual leave after the direction's taken.
Which is still a lot.
Still a fair amount. The direction can't allow taking of periods of leave in less than 1 week, must not require the employee to take a period of annual leave which begins less than 8 weeks after the notice is given or more than 12 months after the direction's given. So there's a window. The direction must really talk about leave that's between 2 and 12 months away. Can't be inconsistent with any existing leave arrangements. And that's not all. That's just about some rules about the direction. What then happens is, if an employer has started this process, the employee themselves can then request to take leave at a different time. So if you've issued the direction after trying to reach agreement, the employee under the award has a right to issue a notice to the employer that they want to take leave, perhaps at a different time, and then there's a series of rules about that request, and again, that request can't result in them having less than 6 weeks after the request is processed. It's got to be taken within a period of 2 to 12 months after the request is made, etc. But effectively, you have a whole heap of rules about directing the taking of leave. An employee can then intervene or reverse or rebut the direction by raising their own request for leave. And so we really end up in a period or a space where there's quite a web or vortex of provisions that need to be complied with if you want to direct someone to take leave under an award. So I would urge significant caution when entertaining the direction provisions for excessive leave accruals.
I think from our perspective as well, that the types of policies and contracts which we routinely review will have a one-liner on this that says the employer may direct you to take leave as reasonable. Given the state of the awards now, to the extent that the employee is award covered, it is much more complicated than that. And look, this may not result in an issue in every case, but certainly the idea that as the employer I can tell people when to take leave and because it's my business, it doesn't flow from the current state of the modern awards.
Absolutely. And obviously, all of these issues are simply in relation to your award-covered employees, not those who are award-free or covered by an EA. To make matters somewhat potentially more complicated, there are currently annual close-down provisions in a number of awards that entitle an employer to close down their business once or twice a year as part of a whole shutdown where people can be directed to take their leave. Those provisions themselves are under review and might be subject to some change over the next 4 to 12 weeks. And so what we also need to be conscious of is that the relatively simple annual close down clause that's currently in your modern award, we're pushing very hard on behalf of the New South Wales Business Chamber actually to try and keep those provisions the way they are, but there's every prospect they might change as well.
I can feel questions coming through that perhaps if that's the time frame, Lewis, I mean, what does that mean for Christmas shutdown this year? Because that would be, I'm sure, probably the most common time in which employers would shut down their businesses.
Look, I think that's a really good question. I'd be surprised if they take effect before the end of this year. We might know what the drafting looks like, but I suspect an effective date will be more like February, March next year. We might go to some more questions in a moment, but before we do, there's also new award provisions in relation to leave in advance, and we've actually set out on your slides there some of the detail. You can agree in writing to take a period of paid annual leave in advance. The agreement must state the amount of leave to be taken in advance, the date on which it's to commence. It's got to be signed, the agreement, by employer and employee or by a guardian or parent if someone's under 18. Other elements, it's got to be kept as the agreement's got to be kept as a record. But this is the interesting one. If on termination, the employee's not accrued back the entitlement to annual leave that they'd taken, then the employer can actually deduct an amount equivalent to what hadn't yet been accrued. And that's quite helpful for employers. Before we move on, Julian, I might just hit you with a few of these questions. Do you feel it's reasonable to refuse annual leave to be taken in lieu of sick leave when all sick leave entitlements have been exhausted?
It depends on the basis. I mean, if the basis is purely that they've run out of sick leave, I mean, it is their annual leave. And my personal view on reasonableness is probably neither here nor there. It's what a commission or industrial tribunal might decide. I mean, I think it would be, I don't know, I think it'd be a difficult argument to make. I mean, it is, if they've got an accrual to annual leave, they're sick, the reason why they want to take a day off is because they're sick. I think it would be difficult, Lewis.
Yeah, look, I think unless there's some critical operational reason that they could turn up to work anyway unwell, it doesn't make a lot of sense.
Yeah.
It'd be a difficult one to refuse, to be honest. Next question, could an employer refuse one staff member leave but then later agree to another staff member taking leave at the same time?
Well, depending on the circumstances, I would say yes.
Yeah, I think it's more about whether your process or reasoning is arbitrary or not. I mean, if there's a reason why for one you can accommodate it, but another you can't, then it might be entirely reasonable to do that. Everything is going to come back down to reasonableness, and I suspect that if there is a legitimate reason why you couldn't accommodate the first but can the second, that should be fine. But if you've arbitrarily said no to someone but yes to someone else, that's where you might.
I think that's right, and I think you're particularly safe on business grounds. If you have a legitimate business-related reason for doing something as a business, for the most part, I think the framework will allow you to do it.
We've got a question from James. Can leave direction arrangements within EAs provide for more simplistic arrangements than set out in the awards, i.e. we can get leave down below 6 weeks, etc.? Absolutely. So as you'd be aware, James, the enterprise agreement process involves the Commission assessing whether the EA terms are better off overall than the underlying award terms. But by and large, the predominant focus of the better off overall assessment looks at pay rates, looks at penalty rates, looks at allowances, looks at minimum engagement commitments, things that have monetary ramifications. Yes, they will look at broader non-monetary entitlements, but we are seeing EA provisions approved that are far more simplistic than the award provisions without significant concern. So absolutely, you can go ahead and put provisions in your EA that might not be as detailed or complicated as the award and provide an easier access to direct people to take leave.
And I think the other thing to say is once you have that agreement approved by the Commission, essentially the agreement applies. You don't necessarily have to worry about the complexities of the award clauses. You've got your simplified clause, you go and use it.
So we might keep going. There's great number of questions coming through, so keep them coming and we'll try and endeavour to address as many as we can. We'll probably do with cash out pretty quickly. Do you want to just take us through the 30 seconds worth of cash out and annual leave?
I can definitely do that. So there is, like the other, I mean, we actually haven't mentioned the 4-yearly review, my favourite topic. All of these changes are coming as a part of the 4-year review of modern awards, and all of these annual leave changes are part of that suite of changes. So as you can see on the slide, there is another process-driven clause where paid annual leave must not be cashed out except in accordance with an agreement under the clause. There are various requirements for that agreement. Critically, you have to agree in writing. The agreement in writing must state certain things, including the amount of leave to be cashed out, the payment to be made to the employee. Again, we need the signature. The payment must not be less than the amount that would have been payable had the employee taken the leave at the time the payment is made, which I guess makes sense but may not apply in every case, so you just need to make sure you jump through that hoop. An agreement must not result in the employee's remaining accrued entitlement to paid annual leave being less than 4 weeks. These are safety net provisions. So this is the ability to cash out annual leave under the awards will not let employers and will not let employees essentially forego their entitlement to NES provisions like annual leave and essentially say, oh, okay, well, I just want the money, I don't want the leave. There are limits to it, and the limit being, in this case, you can't go below 4 weeks, which is, again, a fairly high amount, considering that's your annual entitlement. Critically, the maximum amount of accrued paid annual leave that may be cashed out in any 12-month period is 2 weeks. So that's, again, not a lot.
Yeah.
So these are limited clauses in terms of what you can do. They're not an invitation to be doing extravagant deals with employees. And essentially, like all of these new award clauses, one, they're new, so we need to get across them, but two, they are prescriptive and they're process-based. Step A, step B, step C.
Yeah, absolutely. And so I think they're the main areas you might get queries or tensions around annual leave. Personal carers leave, well, we've dealt with the accrual and the taking of the leave. In addition to that, just a couple of areas where we often see tension. Personal carers leave can be taken in 2 ways. It's either as sick leave or carers leave to support a member of the person's employee's household who requires carer support because of a personal illness or an unexpected emergency. Now, it's interesting, two things about the carer's leave. It goes beyond illness. It actually then extends into unexpected emergencies affecting someone who might require care or support. So it's slightly broader than the personal leave, which is just about personal illness or sickness. Where we get often questions is, oh, well, when can I request evidence? Do they have to be off for 3 days before I can request a medical certificate? Jules, is that the case? Is there a particular, 1 week before I can ask for this and that?
There isn't, and there certainly isn't a requirement that in every case you must get evidence. It will depend. The Fair Work Act says evidence that would satisfy a reasonable person of the need to take leave. Now, critically, what we don't have on that slide in terms of the sick leave part is that you actually have to be unable to perform work. It's not that you've got some illness or you feel like you feel unwell. It's being unable to perform work. As to what evidence that you actually get, it's really interesting. I'm particularly interested in where you get the evidence from. Now, your stock standard is to go to the GP and get nowadays what is a very, very vanilla document which says employee attended to see me and was unfit for work. No detail whatsoever. Now, if you're away for 2 days or 1 day and then you're back to work fully firing, that's probably going to be okay, right? We don't need to investigate that anymore. Interestingly, it's not just doctors who are signing these forms. I mean, you can get for between 25 or I think I've seen it as low as $5 from a chemist, a sick note. Now, that's legitimate. It's a legitimate form in certain cases where it would satisfy a reasonable person of the need to take leave.
And I think this is where there's a real tension here, because question is what would satisfy a reasonable person. Now, if it's a one-off, isolated incident, that might be that scenario. But where you have someone, and also the question is what your policy is. You might have a policy that is clearly communicated to staff that sets out that this is what is required to take personal leave, and you can actually start to press quite firmly for doctor-only evidence. And I would recommend a policy to make that clear. And the other thing to bear in mind is where the role statutory declarations play. It might not be possible to get a doctor's certificate in certain circumstances. If you're in a remote regional area and there's no doctor in that town, perhaps the chemist is the closest available, perhaps the statutory declaration is the best that can be provided in an urgent time frame because there's no doctors in the area. Now, the reality is where this is going to start to become more important is where you have extended absences or regular absenteeism. And that's the point at which you'll be saying, well, look, I'm not satisfied by a stat dec. I'm not satisfied by a chemist certificate or a pharmacy certificate. I require a medical certificate that confirms the nature of the condition, and perhaps you might also be asking for the prognosis when they're going to return. You can issue those types of directions to obtain information to satisfy yourself. But you need to be careful about when you really pull the trigger, so to speak. Someone who's a good employee who's absent once in a blue moon, you're not going to roll up and with an army of directions and all sorts of things. You're going to be a little bit more accommodating about what's provided. It's where you have consistent absences, long length of period, that you're going to start to say, well, a reasonable person in those circumstances would require medical evidence. And that's evidence from a doctor.
That's right. And in terms of a single-day absences being generally not requiring evidence, where there's a pattern of single-day absences, say on a Monday or say on a Friday or say the day after a public holiday, that's when you get to the judgment call of, well, what would satisfy a reasonable person, and do we want to rock the boat in trying to dig a little deeper to see what's going on, or are we willing to just let that slide and we'll go forward?
And the other thing to bear in mind is, so they're the Fair Work Act rules. So they say that this requirement, so the evidence requirement is on each occasion someone takes leave. So there's no rule that you need to wait a week. It is each occasion the evidence needs to be provided, or you can expect evidence that would satisfy a reasonable person. The only thing that might change that is an award or enterprise agreement. Now, some employers commit in enterprise agreements to not requiring evidence after particular periods or over a certain point in time. That would then affect the Act's application. It may be more generous to employees, and in those circumstances, you might be constrained about what you can or can't ask for. Same with your policies and contracts. So we'd recommend employers don't try and cover this field too much. I wouldn't be setting out what evidence you do or don't ordinarily expect in each scenario, or saying we won't ask for it unless you've hit 3 days or unless you've taken 5 days leave. It's generally simpler just to rely on the Act provisions, which means you have the ability to expect evidence that would satisfy a reasonable person on each occasion that leave is taken. Before we get into the next round of leave, we do have a couple more questions that I thought would be interesting to go into. We had someone say we have a couple of employees that have been unable to attend work today due to the bushfires. What leave would you classify this as? Well, that's a fascinating question. I think you really need to explore, one, the legal position, two, the actual practical position you might take. From a legal position, you really need to understand why they're not attending. If it is because, for instance, they are caring for someone in an emergency scenario, it could well be that it's a form of carer's leave. If there's an unexpected emergency affecting a member of their immediate family or household and they are required to look after someone, let's say there's a small child that requires extra care and attention because of the bushfires, that might kick into paid carer's leave. If not, you're really not in a form of established leave under the Act. There is community services leave that we'll come to, but that's about volunteer bushfire fighters that can take unpaid leave. But in terms of an employee looking after themselves, they're really not in a position, if they're not in a position to present for work, they're not in a position to present for work. Technically, you wouldn't have a requirement to pay in those circumstances, and you would then explore, well, am I going to grant them annual leave, or am I just, particularly for a 1 or 2 day absence, you might just effectively provide them some form of special paid leave on the occasion, given the unique nature of the circumstances. But from a legal standpoint, an obligation to pay would probably only arise if if they were caring for someone in an emergency context, or if they're participating in voluntary fire activities or SES activities, then they're not entitled to payment, but they are entitled to unpaid leave. We'll keep charging ahead. There's unpaid parental leave, a right to 12 months unpaid parental leave. That's probably well known. Perhaps lesser known is there is a right to request an additional 12 months of unpaid parental leave on top of the first 12, but that request can only be made before the first 12 have expired, and it can only be refused once made on reasonable business grounds. And if the request is made, the employer must respond in writing within 21 days of the request, setting out the business grounds for the refusal. A few just kind of trigger factors that give rise to who gets and who doesn't get the leave. The leave is only available to employees who have 12 months service, as at the date that the birth occurs, if it's a birth-related leave, or the adoption occurs, if it's an adoption-related leave. For casual employees to be eligible, they need to have been working for their employer on a regular and systematic basis for at least 12 months and have a reasonable expectation of continuing to work on that regular basis had it not been for the birth or the adoption. So that's where you trigger the leave. Perhaps more interestingly is the return to work guarantee. On ending the period of unpaid leave, an employee is entitled to return to their pre-parental leave position, or if that position no longer exists, an available position for which the employee is qualified and suited nearest in status and pay to the pre-parental leave position. And this is really quite an interesting area because...
So I might just set up the scenario for Lewis to speak to. The employee goes on parental leave. That employee's role is covered in some way, either through a person on a parental leave cover, or perhaps the role isn't filled specifically by someone else, but everyone else just sort of changes their obligations and their roles and duties, and essentially that person's work gets done. During the period of parental leave, it dawns on the employer, we might not actually require anyone to perform this role anymore, the person who's on parental leave. Perhaps this role is redundant. This is where many employers find themselves the situation. This is the situation many employers find themselves in, and then they get to the return to work guarantee. Do we guarantee that the employee whose role we now think probably is redundant, are they guaranteed a return to work? And Lewis, perhaps you'll talk about Stanley.
So you have this tension. Well, the Act says, if I read it again, on any unpaid parental leave, I'm entitled to return to the pre-parental leave position, or if that doesn't exist, an available position. It doesn't talk about not being returned, and it doesn't talk about being able to cease the employment during the parental leave. There is an argument on the natural and ordinary meaning of the words used in the Act that you can't actually make an employee redundant during the course of their parental leave, because you would therefore be acting inconsistently with the return to work guarantee. They're not going to get returned to work at the end of their leave. They're not going to be put back in that position or an available position which exists. Their employment's being ceased during the leave.
You're breaking the guarantee.
You're breaking the guarantee. It's no longer a guarantee. It's just a pinky promise. Interestingly, that's not the approach that's been taken by the courts to date. In Stanley and Service to Youth Council, Justice White of the Federal Court looked at this specific issue, and Justice White found that, so an employee was made redundant during their parental leave period. Justice White found that what then occurred is that triggered the return to work guarantee at the time they were made redundant. So one had to assess at the time they were redundant if an available position existed. If no available position exists, then the employer has no obligation. Justice White didn't consider that the employer had to wait until the leave ended, which is quite interesting because the employer wouldn't really be in a position to return halfway through the leave period. They've sought 12 months off. Ordinarily, you'd expect they're not going to be in a position to return until that 12-month period concludes. And so it's an interesting decision. It's one that's broadly been accepted by employers, the Fair Work Ombudsman on its communications, on its website. But we might see more in this space because there are really two conflicting approaches you could take to the return to work guarantee. Certainly the federal court to date has adopted one that seems a bit more beneficial to employers, but we might not have heard the end of that yet.
Particularly because it does seem to undermine the concept of a return to work guarantee if that return to work guarantee doesn't include or has a carve out for being made redundant while you're on parental leave.
Now, the other thing you need to think about when it does come to redundancies is if you are looking at consultation during if you are looking at redundancies during parental leave, you have specific consultation obligations to inform the employee on parental leave about any major changes that might affect their employment. Redundancy would obviously be one, restructures another, and they have a right to be consulted whilst on leave. So you need to not forget about them.
This is everyone as well. Occasionally, in terms of when you hear consultation, you think, oh, well, the award consultation clause or the EA consultation clause. The clauses that Lewis is talking about are in the Act. They apply generally, and so there are obligations, regardless of the coverage of the particular parental leave employee, to engage with them during their period of leave.
Just a quick one before we then move to the next area. Someone's asked, can someone take, this is Zelia, can someone take personal carers leave to extend their paternity leave? Difficult. You need to establish the grounds for taking personal carers leave. So are they sick themselves? Probably not. Are they required, if we go back to the carers test, are they required to give support to someone because of a personal illness or injury affecting them or an unexpected emergency? I hazard a guess probably not. So the notion that you could just take sick leave or carers leave to cover ongoing maternity leave, probably not going to work because it's not about personal illnesses or injuries or unexpected emergencies. Now, if, for instance, there is a scenario where your normal care has fallen through and you automatically just have to care for a child for a few days, yes, that would be able to be used for carers leave, but not kind of a predetermined, pre-organised form of de facto parental leave. You couldn't use carers leave for that.
Fair enough. I mean, I think, was the question paternity leave?
It was actually.
Yeah, so I think maybe the scenario would be, say, 2 weeks of paternity leave or 2 weeks of paternity leave, and perhaps after that 2 weeks, let's say it's a scenario with a mother and a father and a child. The mother is ill, unable to care for the child.
And so someone else needs to care.
Someone needs to...
Well, that could cover it, yeah.
I think that's fair enough.
Julian, you're the expert on family and domestic violence leave, only because you were heavily involved in the proceedings pertaining to this.
I was. Family and domestic violence leave is a clause in the Fair Work Act now. It's part of the NES, but it is only relatively new, and the genesis of the clause was a 4-yearly modern award review case that was run by the ACTU, I think in 2016. That case was to introduce into all modern awards an entitlement to 10 days paid family and domestic violence leave. What the Commission came up with after a long case was an entitlement of unpaid 5 days, which went into all modern awards. Quite quickly, that got picked up by the federal government to be put into the Fair Work Act as an NES clause. Now, there's two critical things to understand about this form of leave, and it is an interesting form of leave in comparison to the other forms of leave. Firstly, it's available in full at the start of each 12 months of an employee's employment. So you get your 5 days as a block at the start. You don't have to accumulate it. You don't have to, it's not, there's no maths involved. You get your 5 days that you can use in that 12 months. The other aspect is that it goes to casual employees as well, which is slightly unusual for leave. The aspect which I think is really important and perhaps isn't communicated particularly well, is that it is a leave to do something. So, one, you do have to be subject to family and domestic violence as domestic violence scenario to access the leave. But you also, in order to access the leave, need to be doing something which you ordinarily wouldn't be able to do outside of work time. So I actually need time off because, for example, I need to go to court. I need time off because I need to relocate myself or my family to get out of a family domestic violence scenario. You need to be doing something. It is not just simply an entitlement to leave where, because I am subject to family and domestic violence, all of a sudden I can take the 5 days off. Now, there's a couple of things which everyone really needs to have a bit of perspective about this form of leave. One, it's unpaid, which means the scenarios where this leave, I think, will be taken, there's very little information on what's actually happening out there in terms of this leave because it's so new. But the likelihood that, I think it's a strong likelihood that an employee will take paid annual leave or potentially paid personal carers leave in preference to taking family and domestic violence leave if they're so unfortunate to be subject to a scenario like this. The other thing that really people need to understand is obviously, and it's on the last point of the slide, employer must take steps to ensure confidentiality over the request and the content of the request is kept as far as reasonably practicable, confidential. I mean, this is not a form of leave which necessarily there are public registers of accrual times. This is not a form of leave where you would publicise generally to staff that so-and-so is, that your employee is on family and domestic violence leave. It's a form of leave which is, it really only applies in very, very serious circumstances where an employee is going through a particularly serious incident or scenario. And I think this is where managerially, businesses just need to show a bit of, business IQ, emotional IQ to manage this in a way. It's not something which is of the same nature as annual leave or personal carers leave. And I think for the most part, and certainly the evidence in the case suggested that employers generally are handling these issues privately in a non-systematised way. They're handling it personally to deal with a particular scenario, and in most cases, employers, may just give the employee paid leave or obviously flexibility where needed.
Last two types of leave, jury service, community services leave. Might start with the community services leave because it's quite topical. This is unpaid leave to deal with voluntary firefighting activities, SES or other emergency management activities. It's not restricted in terms of time frame. It's at large, unpaid leave to deal with those things. Separate legislation actually applies to the Defence Force reserves, who also are protected from victimisation if they engage in reservist activities. And that's, you'll see the reference to the Act for the Defence Force up there. Jury service is a mixed form of leave, because for the first 10 days, the employer actually has an obligation to pay the employee the difference between what they got given from the government and their usual salary. So the first 10 days is paid leave, but after 10 days, jury service leave flips to unpaid leave. Now, some employers as a policy might provide a more generous form, but under the Fair Work Act, it's only the first 10 days that need to be paid, and it's subject to the usual evidence requirements. Unfortunately, you can have jury service that goes for really significant periods of time. There's not much that can be done about that.
Absolutely. It really is luck of the draw. And for those who, some people, it's a very, very short engagement. For others, it's much longer. So that's something that when it arrives, businesses need to work out how they're going to deal with it.
Now, we've received an avalanche of questions, so try and knock over some in quick-fire format. We've got Sarah saying, can an employee request sick leave for a future dated doctor's appointment? For example, they may have a specialist appointment in a month they need to travel to another city for. That's an interesting one, and it actually comes up against a different example, which often comes up, which is if someone books a specialist appointment or I've got a separate question from Deanna, someone has pre-planned surgery with a recovery period when they are unfit to work, should it be taken as annual leave or sick leave? I think both Deanna and Sarah, your questions are quite linked. The reality is if you are pre-booking an appointment, whether it be for surgery or in relation to a particular condition, it doesn't usually tend to fit well within the format of personal leave or carer's leave, because if it's pre-booked, it may be that you are fit to work, you've just, for the sake of convenience, gone and scheduled the operational or whatever it is at that time. So it may be that a form of annual leave could be required for that booking, but what happens is after the appointment or after the surgery, wisdom teeth surgery is a good idea, you may then become unfit.
It's a good idea.
That's a good example.
It is a good idea.
It is also a good idea. Wisdom teeth surgery is a good example. You might pre-book it, so you might be fit at the time, but then having had the surgery, your mouth's blown up like a watermelon and you actually can't talk. All of a sudden you're drinking through straws, you're really not in a state to be at work. Then you're unfit. And so then you would be entitled to personal leave. But not necessarily entitled to personal leave just because you've gone and arranged an appointment at a particular time or a booking with your dentist or whatever the case may be. We've got another question, Julian, similar to one before. We have a policy that employees can have 3 single days of sick leave per year without a certificate. Can we ask this?
Can you have that policy?
Yeah.
Oh, certainly you can have the policy. As Lewis mentioned before, I mean, I think we'd want to be careful about setting up rules like that. I think in some respects it kind of can create a behaviour or create a system where, one, you might be bound by that. So in certain circumstances you might actually really want the document. In other circumstances it might make me as an employee say, oh, well, I've had 1 sick day, maybe I'll take 2 more and I don't need to bring a note.
Yeah. We've got a question about compassionate leave, which we didn't specifically cover. The question from Terry, Fair Work indicates 2 days is allocated for employees grieving a family member. If an employee were to obtain a medical certificate for an extended period, is there an option to challenge this? Being sick is different to grieving as there is a specific allocation in compassionate leave. Interesting one there. I mean, compassionate leave is 2 days leave, paid leave, when there's a death of a family member or immediate household, or there's a serious life-threatening development, illness affecting them. That is the paid compassionate leave. If because of that, someone becomes personally unfit, for instance, their grief may reach the point that they actually suffer from a mental condition. If they are certified as unfit for work, they could enter into personal leave legitimately. So I appreciate, Terry, that compassionate leave is different to personal leave, but if they do develop a mental condition, it would probably be depression, anxiety, other kind of medical diagnosed conditions that could form the basis for personal leave after the incident.
I think that's right. I mean, it is always important, and one of the things I often say to people is, we are not doctors, and often business owners aren't doctors. To the extent that an employee has said that they are unable to work and has got a medical opinion which states that, it really is difficult, unless you're going to get an alternative medical opinion, to really quibble with that. And certainly I can see a scenario, notwithstanding I'm not a doctor, that an employee could, as a result of a death of a family member, develop something which would incapacitate them.
So a final question to end on might be slightly more controversial or interesting. Lee asks, her question is interesting to ask, evidence of a mental health day, ? So I think the question being asked is, well, what's a mental health day? What can we require? What's all that about?
The reason why I find that particularly interesting, because I think the concept, at least as I understand it, a mental health day it's kind of a euphemism for a day off, not necessarily because you've got any physical ailment or particularly any inability to work, but more as things have become very busy, more just as a sustaining absence whereby someone could maintain their mental health by having a break from work. Now, the environment where that is being done or potentially encouraged, I wouldn't say is an environment where people are asking for certificates.
Well, that's probably right. And I think the reality is, under the Act, there isn't really such a thing as a mental health day. I mean, yes, if someone is suffering from considerable strain, there might be work health safety considerations that mean they may need to be away from work. They might not be fit, but you're either fit or you're not. So there's either medical evidence to suggest you're fit for work, in which case the Fair Work Act says if you're fit, you're expected to work. If you're unfit, then you're entitled to take personal leave. I think Julian's right. We're seeing this emergence of mental health days more as some kind of progressive approach some employers are taking to try and just enable people who they particularly identify as hardworking to maintain a level of balance in their life. But it's not a form of leave expressly recognised in the Act, nor to which there's an express entitlement to. The Act is focused on fitness for work or unfitness.
You certainly could take a day off to deal... You certainly could be incapacitated by mental health issues, and to the extent, if that's what you're talking about, certainly you could get a certificate for that.
Absolutely.
But to the extent that a mental health day is used in air quotes, I guess, to say this is a day off for a person who needs it, not necessarily in a medical sense, but in a well-being sense, it's not something where you necessarily even could get a medical certificate for, and therefore probably one that you wouldn't ask for one.
So that's effectively the leave presentation for this webcast. We hope it's been informative. We will send out the slides to those that request it. We do have a few things that we're just going to say to close off. Anyone who has concerns about the Mondelez case, feel free to reach out and we can talk to you about specifically on a case-by-case basis how to respond, noting that there is now this obligation under the Fair Work Act to treat personal leave a particular way, and one that employers can't just ignore. There's some additional assistance we can give in terms of training on some of these matters, particularly for payroll, etc. We're regularly conducting training courses, so it's not just on these topics, but any others. Feel free to reach out to us on that. And I think, but can't confirm, we might have one last webcast or webinar for the year coming up in December, so you can look out for that as well. Other than that, I think that's pretty much it from us.
Thank you so much.